Trading Pty Limited application for a trading license held today on the 4th of October 2024. My name is Nhlanhla Kumete. I'm the full-time regulator member primarily responsible for electricity regulation. I'll be the chairperson of this hearing. I'd like to introduce the other members of the panel, starting with Ms. Nomfundo Maseti, who is a full-time regulator member primarily responsible for pipe gas regulation and a member of other committees, but she's actually a member of the ELS. Madam Maseti.
Good morning, Chairperson, and good morning to the stakeholders and members of the public. Chairperson, I will activate my video later on. Thank you very much.
Thank you, Madam. I'd then like to move on to introduce Mr. Mozi Nkiza, who is a full-time member of the full-time regulator member, primarily responsible for petroleum pipeline regulation, a member of other committees at NESA, but also a member of the ELS. Mr. Nkiza.
Thank you, Chairperson. Good morning to all the attendees, the presenters, and the members of the public that are following us through the various live streaming platforms. Thank you.
Thank you, Mr. Nkiza. We do have the chairperson of NESA, who is also a member of this committee, Mr. Thembani Bokula. However, he generally, because he's also a CEO of a trading company, when we're dealing with these traders, just on a cautionary note, not because of any pecuniary interest, that he normally recuses himself, but he is going to be on the call, but will not necessarily be participating in the questioning of the presenters. We also have Advocate Nomalanga Sithole, who is the Chief Executive Officer at NESA, a member of other committees at NESA, and also the member of the Electricity Subcommittee. Advocate Sithole.
Good morning, Chairperson and members of the ELS and everyone who have joined us for this particular hearing today. Thank you, Chair.
Thank you, Madam. Last but not least, we have Ms. Tembeka Simane, who is a part-time regulator member at NESA, a member of a number of committees, chair of the Finance Committee, but also a member of the Electricity Subcommittee. Madam Simane.
Thank you very much. Good morning to you and good morning to the members of the public as well as our colleagues at NESA. Thank you.
Thank you, Madam. That's the panel that will be listening and answering and asking questions of the presenters. This hearing was duly advertised in the Business Day, the BEALD, and all NESA social media platforms, as well as on the NESA website. It is held in accordance with the National Energy Regulator Act of 2004, in which all affected parties are given an opportunity to submit their views and present relevant facts and evidence to the energy regulator. This hearing is governed by the NESA rules on public hearings, which can be summarized as follows. All parties that are wishing to make a presentation will need to make those presentations under oath. Number two, the presenters have been allocated 20 minutes each to present, and a further 20 minutes for questions and answers. Only members of the panel may ask questions to the presenters. However, members of the public may give or may send questions to walter.mabunda@nersa.org.za, and the panel will decide on how to deal with those questions. Number four, should presenters wish to present information they consider confidential, the panel will make a ruling on whether to close the hearing or to have the information submitted in writing. The recording of this hearing, which is done through our recording system, will be the official record of this meeting. The house rules for the meeting are simple. We just request that to please always put yourself on mute when we are not presenting. We also request that you always switch off your video unless we are requested to switch it on. And lastly, if you are presenting, to kindly put your cell phones to silent. We have received 4 requests to present, but the first 3 presenters have requested to combine their presentation, at least to have their presentations to flow one after another, which request has been granted. We would therefore swear all of the presenters at the beginning of the session and then allow them to then present. Yes, as indicated, each presenter had been allocated 20 minutes. Each presentation had been allocated 20 minutes. However, we would really implore that seeing that there's going to be a flow of the 3, we would really appreciate it if we could actually be able to have all 3 presentations made as expeditiously as possible, perhaps no more than 40 minutes, but we're not going to infringe on your rights to present, but we really just request that you actually grant us some kind of saving, because those presentations would need to flow from one end to the other. We also request, if it's possible, that the presenters to kindly share those presentations with us through Mr. Walter Mabunda, same email address, walter.mabunda@nersa.org.za. That will assist us greatly as for the members to be able to then follow the presentations and be able to ask the questions. With that, I'll then move us to the order of the day and ask the presenters today, those that had expressed an interest to present. The first 3, Mr. Andrew Taylor. I'm not sure it's a Mr. or a Miss. Carol Cornelius, Andre Norkia, and Vuyon Doi. All those presenters to please to just switch on your videos, and so we can actually. Thank you. We will start with is it Andrew, the first person?
That's correct, Mr. Chair.
All right. Can I then ask the question, do you object to taking an oath?
I do not.
In that case, can you kindly raise your right hand and affirm the following? Do you solemnly declare that the information, the evidence that you are going to give to this panel is the truth and the whole truth?
I do, Mr. Chair.
For the record, please state your name, the organization that you are representing today, and your designation in it, please.
My name is Andrew Taylor, and I represent NOA Group Trading, the applicant, and my designation is a director and the head of trading.
Thank you. The next presenter will be Carol. Thank you, Carol. Okay. Would you object to taking an oath?
I would not.
Thank you. In that case, kindly raise your right hand as we've done and affirm the following. Do you solemnly declare that the information and the evidence that you are going to give to this panel is the truth and the whole truth?
I do.
Thank you. For the record, kindly state your name, the organization, the organization that you are representing, and your designation therein, please.
I am Carl Cornelissen. I am representing NOA Group Holdings and NOA Trading, in which I am a director in both entities.
Thank you. The next presenter will be Andre, right?
Yes.
Correct. Andre, would you object to taking an oath or an affirmation?
I do not.
Thank you. In that case, kindly raise your right hand and affirm the following. Do you solemnly declare that the information or the evidence that you are going to give to this panel is the truth and the whole truth?
Yeah.
For the record, kindly state your name, the organization that you are representing, and your designation in it, please.
I'm Andre Norkia. I represent NEC Limited, and I'm the National Environmental Sustainability Manager.
Thank you. Thank you, Andre. The last presenter is that we saw in is Vuyo. Do you object to taking an oath or an affirmation?
No objection, Mr. Chair.
Thank you. In that case, kindly raise your right hand and affirm the following. Do you solemnly declare that the evidence or the information that you're going to give to this panel is the truth and the whole truth?
I do.
For the record, please state your name, the organization that you represent, and your designation in it, please.
My name is Hlompo Vuyo Ntoi. I represent A4 General Partner, Pty Limited, and I'm a director of said entity.
Thank you so very much. All right, now we've sworn in all of the presenters today. So can I hand over back to you? I'm sure you as the team have agreed in terms of the procedure, who's going to come in first, and we can sequence, and as has been requested, if you can save us time, we'll really appreciate that. But we will not infringe on your rights to actually present. So can I hand over? Can I then?
Yes, absolutely, Mr. Chair. Thank you very much. And just a note to appreciate the concession around the consolidation of presentations. We will shortly share our presentation. Honourable regulator members, it gives me great pleasure to appear before you today to present NOA Group Trading and its application for a trading license. My name, as we said earlier, is Andrew Taylor, and I'm a director of NOA Group Trading. Through this presentation, we intend to demonstrate that NOA Trading is a bona fide applicant, and the application is one which is compliant with all relevant regulatory requirements, one which has followed due process, and one which evidences NOA Trading having the technical, financial, and administrative capacity to act as a responsible and prudent licensee and to operate a sustainable electricity trading business in South Africa. In support of our presentation, I am joined by some of my colleagues at NOA. Mr. Carl Cornelissen, who is the NOA Group Holdings Chief Executive Officer, Mr. Iqbal Sirkot, the Chief Financial Officer, Ms. Lesedi Modise, the Chief Investment Officer, Mr. Matthew Munnick, an Investments Manager, Mr. Sibusiso Baba, a Sales Engineer, and Ms. Robin Bronstring, a member of the legal team. In addition, as we have heard, we are joined online by representatives from Netcare, Mr. Andre Norkier, and from AIM, Mr. Hlompo Vuyo Ntoi, both of whom appear in support of the NOA Group Trading application. NOA Group Holdings is the holding company of a group of companies incorporated to deliver innovative renewable energy solutions to South African energy consumers. We have secured in excess of 3.2 billion rands of equity capital from Old Mutual's Africa Infrastructure Investment Managers in order to implement and operationalize our business model. We have recruited an experienced management team with an excess of 200 years of cumulative experience. And NOA Group Trading, a wholly owned subsidiary of NOA Group Holdings, has been incorporated in order to package and deliver these innovative renewable energy solutions.
Apologies, Andrew. Can I just request that everybody else, please mute yourself. Kindly mute yourself.
Thank you, Mr. Chair. Maybe just to reiterate then, NOA's wholly owned subsidiary and the applicant before you today is NOA Group Trading, an entity that seeks to package and deliver a suite of customer-centric energy supply solutions to these consumers. Once NOA Trading has been granted a trading license, we intend to buy electricity from trusted independent power producers and wheel these electrons in accordance with NERSA's approved tariff structure and whilst adhering to prevailing wheeling policy to these energy consumers in South Africa. On the slide before you is a simplified timeline of the process that has led us to this hearing today. After applying in April 2024, we received confirmation of the successful outcome of our confidentiality application on the 27th of May. This was followed by the prescribed 30-day advertisement period during which NOA Trading's license application lay for inspection at multiple locations and was translated into multiple official languages and published in multiple national and local newspapers. NOA then received limited clarification requests from NERSA, but answered these as soon as they were received. It is noteworthy to point out at this juncture that no objections were received within the prescribed advertisement process, which ran until the 4th of August 2024. Finally, we wish to remark that we are encouraged by the expeditious process which NERSA has run in respect of our trading license application, yielding a public hearing within 6 months of the application having been submitted. NERSA's licensing team is to be commended on this milestone, and we are grateful for the assistance provided to date. On this slide, we touch on the business model and the broader contracting structure that NOA Trading intends to employ. NOA designs customized energy supply solutions to answer the unique needs of each customer, which serves as the core of our solution design process to deliver renewable energy solutions and energy which is procured from a fleet of large-scale generation facilities and aims to serve and supply an aggregated base of customers. These customers enjoy cost savings relative to alternative electricity suppliers and are afforded transparent increases, which provides predictability to one of the biggest input costs in businesses in South Africa today. Crucially, this also serves to assist customers in their net zero ambitions, decarbonizing commercial and industrial activities, which keep South African businesses competitive on the global stage. This is only made possible through the significant equity support made available by our parent company, NOA, and its equity investors, AIM, from whom we will shortly hear some of the reasons underpinning their contributions to realizing this business model. However, the matter before the regulator members today is depicted graphically on the slide currently on display. Starting from the left of the image, the generator Wind Garden is a ring-fence special purpose vehicle incorporated to construct, own, and operate an onshore wind farm. Wind Garden has executed a distribution, connection, and use of system agreement, which lists NOA Trading as a nominated third party with Eskom SOC. Further, it has executed a generator power purchase agreement with NOA Trading, which allows NOA Trading to purchase all of the energy generated by this generation facility. NOA, for its part, has then entered into a customer power purchase agreement with Netcare, aiming to serve the 6 Eskom-connected premises, which are the subject matter of this application. Now, at this stage, it is worth pointing out that each of these agreements are suspended from being effective until we have the necessary license issued by NERSA. As indicated in the previous slide, the trading activity will be confined to the 6 Eskom-connected premises owned by Netcare, which would be supplied with energy sourced by NOA Trading and procured from the Wind Garden generation facility. We would also highlight for the attention of the regulator members that the tariff that has been agreed with the customer is a blended tariff, which takes into account the time of use categories published in Eskom's most recent tariff booklet and which escalates at CPI each year. We further confirm that the tariff realizes a cost saving for the customer, demonstrating value for money, while still yielding a sustainable margin for NOA Trading in order to service its GPPA payment obligations and the operating expenses incurred in order to do so. Finally, the energy tariff paid to the generator under the GPPA is sufficient to allow Wind Garden to cover all of its use of system charges levied in accordance with NERSA-approved tariff structures and the distribution tariff code. Under these provisions, of course, the generator is obliged to compensate the network operator for the use of its existing infrastructure, which requires that all customers make a fair contribution toward the use and upkeep of the network. Briefly then, the generator, as alluded to in the prior to this in the presentation, is Wind Garden, an onshore wind generation facility comprised of 21 4.5 megawatt wind turbines registered with NERSA and which has an amended distribution, connection, and use of system agreement entered into between Wind Garden and Eskom SOC on the 9th of July 2024. The customer is Netcare Hospitals, a subsidiary of blue chip listed hospital group Netcare Limited. Netcare ran a competitive tender process in order to select a renewable energy service provider to supply 6 of their Eskom-connected facilities as part of their broader renewable energy and net zero strategy, which sees Netcare take aim at an aggressive net zero commitment by 2030, as we will hear from Mr. Nokia later on in this presentation. We understand that Netcare will continue to be liable for all Eskom distribution charges levied in accordance with the approved NERSA tariff structure, thereby ensuring that the contribution required to be made by all customers is made to the upkeep of the network infrastructure, and all other charges remain payable. Now, while we have no doubt that the honourable regulator members are very familiar with the Eskom and NERSA approved wheeling frameworks, we did think it prudent to confirm by way of this slide that the transaction before NERSA today in this license application fully complies with and intends to comply with the prevailing regulatory and wheeling frameworks in operation. To achieve this, as we have seen, on the 9th of July, Windgarden entered into an amended distribution connection and use of system agreement, which reflects NOA Trading as the nominated third party, allowing the generator contractual access to the Eskom infrastructure and NOA the right to execute the allocation notices on behalf of the generator. NOA, in collaboration with Netcare, is in the process of updating the various electricity supply agreements between Eskom and the customer to allow for wheeling from the generator to take place. But crucially, it is worth noting that these would still need to be amended to allow NOA Trading to act as the nominated third party under these ESAs once NOA is a licensed trader. It's furthermore important to emphasize that the wheeling policies and the use of system charges levied are intended to ensure that Eskom distribution is kept economically whole during this wheeling transaction. In order to give effect to this wheeling transaction, NOA Trading has invested significant time and resources in developing a bespoke technology platform together with trusted industry experts. The platform comprises of 3 layers, as is illustrated on the current slide. First, a meter data management seeks to draw data from the generation facility check meter to verify electricity production, together with real-time access to the customer's check meter, which is used to verify and confirm electricity consumption. This information is then used to, amongst other things, prepare forecasts for energy production and consumption using our analytics and risk management layer. The output of these elements culminates in the ETS, or energy trading system, which executes on the transaction and submits allocation notices to Eskom and issues invoices to the appropriate parties for the electricity allocated in this manner. Of course, even the smartest technology needs a talented group of individuals to realize its potential. At NOA, we are extremely proud to have successfully recruited a team of industry experts with more than 200 years of cumulative experience. Our interdisciplinary team, while staffed with 7 full-time equivalent team members, is able to draw upon a shared service model with our parent company, NOA, to fully capacitate NOA Trading. With domain expertise ranging from finance to data science, technology, and legal, NOA Trading is confident that it is able to handle the dynamic and rapidly evolving market of electricity trading in South Africa. None of this would be possible, of course, without the very significant capital contribution that has been made by our key investor, AIM. To this end, NOA has raised over 3.2 billion rand to operationalize the business, ensuring that NOA Trading is a bankable off-taker for it and electricity supplier through the provision of various guarantees to both generators and to customers. We will shortly hear from our key equity investor, AIM, who will describe the importance of platforms such as NOA and NOA Trading to deploy the very significant sums of capital into long-term, reliable asset classes like renewable energy generation facilities to accelerate the objectives of a liberalizing electricity supply sector whilst contributing to the energy security of our country. Now, prior to concluding this presentation, honourable regulator members, we would like to invite representatives from Netcare, Mr. Andre Norkier, and from AIM, Mr. Hlompo Vuyo-Ntoi, to address this forum in support of the NOA Trading's license application.
Thank you very much. So I'm Andre Norkier, as mentioned previously, and I'll be representing Netcare as the client in support of NOA Group Trading. Next slide, please. So just as an introduction, who is Netcare? I believe most people are aware who Netcare is specifically, but Netcare is South Africa's biggest private hospital group. We currently have 44 hospital facilities. We also own more than 90 Mediclinic, Medicross facilities, and we also have the KISO mental health hospitals that we're looking after. So just to give some background into sustainability, So Netcare sustainability program started in 2013, and at that stage we really aggressively started focusing on how to reduce our carbon emissions and our energy impact on the grid. Ultimately, to date, we've reduced our energy consumption by more than 39% per patient day, and we also on our water side we've reduced it by 28%. So what we've recently done is we've set quite an aggressive target, as mentioned previously by Mr. Andrew, is that we've set a zero Scope 2 emissions target by 2030, and then ultimately reducing our full Scope net zero by 2050 for that matter. Throughout the years, we've received multiple awards. To date, we've got 38 regional and international awards, all received. We just last week received the Corporate Company of the Year from the Association of Energy Engineers back in Washington, or the United States of America. So our climate change objectives and commitments, as I mentioned previously, is ultimately that we want to reduce our Scope 3 or Scope 2 specific emissions to zero, and this wheeling transaction and ultimately buying renewable energy from NOA Group through this platform is going to help us to achieve that goal. And just again, I want to make mention that Netcare is presenting this in support of NOA Group trading license application. Next slide, please. So NOA trading provides several critical benefits. Firstly, it gives Netcare access to utility-scale renewable energy facilities to address the limits of embedded generation. It also allows us to fully be able to offset all of our emissions. As most of the members know on this meeting, is that solar PV can only take you that far, and you need alternative forms of energy generation to ultimately meet your zero Scope 2 emissions targets. Decarbonation and facilitation of achieving net zero ambitions through renewable energy certificates. And what this does, it increases our competitiveness in the market. Firstly, one of Netcare's key strategies is ultimately to reduce all of our operating expenses that we have associated. It also aligns with the NHI process, where we're trying to reduce our cost as far as possible, giving our customers ultimately better healthcare at a reduced cost. Also, decreased cost through energy saving trickles down and makes South African businesses more competitive. So the benefits of trading and the ease of contracting, and that is that is the main reason why we're going with NOA trading here. So ultimately, as was mentioned earlier, we went through a big competitive process, a tender process, where we invited multiple parties to the table. And ultimately, NOA Trading came out as the winner of that tender process. And since we've been engaging and ultimately signing energy supply agreement with NOA. That's everything from my side. Thank you very much.
Okay, Chairman, regulator members, nursery executives, ladies and gentlemen. My name is Hlompo Vuyontoy, the Co-Managing Director of African Infrastructure Investment Managers, or AIM as it is commonly known. Today I stand before you on behalf of our company, a proud member of the Old Mutual Group. Since our inception in 2000, AIM has been at the forefront of infrastructure development across South Africa and the continent, managing investments worth over $3 billion and pioneering over 30 large-scale renewable energy projects. Our mission is guided by the necessity to foster sustainable growth and significantly improve the quality of life for the South African population by ensuring a reliable, cost-effective energy supply. Our projects span key infrastructure sectors, including transportation, ports, digital infrastructure, and notably energy. In 2012, with the initial establishment of large-scale private electricity generation becoming a reality, AIM embarked on an ambitious journey to decarbonize South Africa's economy and cement its position as a globally competitive hub for renewable energy. We saw the strategic importance of investment into renewable infrastructure as vital for South Africa's growth, a vision supported by a well-established wheeling framework. It is on this basis that we have become the single largest equity investor in this sector in South Africa. This vision led us to seed the NOA platform with 3.2 billion rands in equity capital for the construction of its first 500 megawatts of renewable energy facilities, incorporating wind, solar, and battery storage technologies. Our initiative, NOA Trading.
Sorry to actually disturb you. Are we looking at the one slide, or are you wanting the slides to be moving? Sorry.
No. It's sorry. It's a speech. It's a speech rather than a presentation. Yes.
Okay. No, thank you.
Okay. Our initiative, NOA Trading, once awarded a trading license, will not only support NOAA's own assets, but will also empower other independent power producers to facilitate energy procurement and enhance renewable energy supply to the larger South African market. Investing in NOA and similar platforms is not merely a business strategy. It's a commitment to the people of South Africa to improve their energy access, reduce costs, and diversify our energy sources. It's about building a resilient energy future where private capital plays a crucial role in the energy networks build-out for both generation and transmission. We are a conduit through which domestic pension fund capital is channeled towards solving today's challenges. Therefore, we urge NERSA to grant NOA Trading a trading license. This license is more than just a regulatory approval. It is a gateway that will accelerate the investment of private capital into a robust energy network. It will enable AIM and other investors to continue to contribute to South Africa's energy transformation and economic prosperity. Granting this license will affirm South Africa's commitment to promoting private investment in renewable energy, fostering competition, and supporting strategic initiatives like NOA, which are critical for our nation's sustainable development goals. Ladies and gentlemen, the future is renewable, and the actions we take today will define the legacy we leave for the generations to come. We stand ready to drive this change, and with NERSA's support for NOAA's trading license, together we can power South Africa towards a brighter, more sustainable future. Thank you.
Thank you so very much. In fact, I'd like to applaud you for giving us time back, because clearly, it was a nicely synchronized three set of presentations. With that, can I then request the members of the panel to then engage with the presentations, all three presentations, please, starting with Mr. Mkhize.
Thank you, Chairperson, for the opportunity, and thanks to all the presenters, especially also for keeping to the time, giving us more minutes back. Just two questions from my side. I note on slide 2, the first presentation, that there's talk of 51% black ownership in the next 24 months. Just like to understand as to where do you stand right now, and how will you phase that in to get to the 51 plus? And then on slide 5, there's indication, which is confirmed also in the second and the last slide, that the 6 Netcare premises are connected to Eskom. I'd just like to understand if you have consulted Eskom regarding your trading, envisaged trading and trading license application, and if you have come to some understanding thereon in any shape or form as an agreement. I'll stop there. Thank you, Chairperson.
Thank you, Mr. Mkhize. Madam Massetti.
Thank you, Chairperson. Chairperson, I would like to start where Mr. Mkhize left, just to clarification as to whether there is an understanding or an agreement concluded with regards to the use of system agreement between NOA Trading as well as the distributor that owns the network over which the trading activity will be taking place. I would like to understand that. And also if NOA Trading has an idea of the use of system charges that will impact on its cost, given the fact that during its presentation it has indicated that it will be in a position to recover or to cover all of the other costs, including the charges that will be levied by the network operator or network owner. So without knowing how much, how would you know the viability of the project to start off with, and how much the consumers will be affected? What if that will have to be charged at the end of the day if the charges for the system you don't know at this point in time? And how would you know that your tariff will be competitive, and that there will not be issues of a margin squeeze or squeeze in the area that you will be operating if you are facing competition, particularly from the distributors operated in the area. So I would like you to reflect on that, and especially if we don't have that information before us at this point in time, just the possibility of system charges that may make it difficult, or that may give rise to a margin squeeze or a price squeeze, if that can be clarified. The other issue that I would like to clarify with NOA Trading, in terms of its intention to expand within the trading market in South Africa. I want to check, because it seems from what I've looked at that currently it will be focusing on the areas where these 6 customers will be operating. Is that the intention, to limit the operation of your trading activities only to these areas? Are you not looking at expanding to other areas, or also getting other customers in other areas? Then the last question that I have is just to establish whether in terms of the off-takers which anchor this business activity, which is your trading, whether you have already signed agreements with them for purposes of this license, just to understand that these are the anchor customers for the regulated activity that you're seeking the license for. I would like to stop there, Chairperson. Thank you very much.
Thank you, Madam Maseti. Mr. Mkhize, I assume that's a lingering hand, or you wanted to follow up with an additional question?
Thank you. Chair, lingering hand.
No, thank you. That's fine, Mr. Mkhize. Those are the questions from the members. I'll actually just allow you, Mr. Taylor, Mr. Norgia, Mr. Ndoi, to just respond to the ones that you want to respond to. But I do want to also indicate that you've got an option. You have an option of choosing which of the questions you want to respond to, both verbally and also in writing. So you can then supplement all of your questions. So I guess the issue might be in the event that you notice particular line of question from the members that you believe need to be supplemented, we do give you 7 days for you to do that. So, but over to you. You've got your time to respond. Thank you.
Excellent. Thank you very much, Chairperson Gumede. And thank you to the regulator members for their insightful questions and engaging with the application submitted. I believe we will start with regulator member Mkhize and his question in relation to the 51 black ownership statement that is made on the second slide. I think in that regard, we would confirm that the current status of NOA Group Trading is that it is 100% owned by NOA Group Holdings. And we receive, through the modified flow-through principle, in excess of 20% current black ownership through our shareholders and the shareholders of NOA Group Holdings, into NOA Group trading. I think in the application that we have submitted, we put forth a cogent and comprehensive description of the strategy that we intend to employ in order to achieve the 51% black ownership that regulator member Mkhize refers to. And finally, in that regard, I would confirm that as we have not yet commenced trading, we are still a level 4 BE exempt micro enterprise, and so have that status as part of our application also. Then I believe the second question, if I understood correctly, because regulator member Mkhize's connection was not 100% clear, so please do reiterate if I don't hit the target on this one. But in regards to our engagements with Eskom, I mean, these are numerous. Both as NOA Trading, we are obliged to provide certain information in terms of the generator power purchase agreement to allow generators to update their registrations with NERSA, but also to amend agreements such as the distribution connection and use of system agreement, which regulates the generator's access to the Eskom infrastructure. And then in addition to that, in order to assist our customers to implement the wheeling transaction, NOA Group Trading engages with Eskom on numerous dimensions to effect these amendments to the electricity supply agreements between Eskom and the customers. Then I believe regulator member Maseti's question was in relation to how we would ensure that the generator is able to recover costs. And whilst these are not disclosed to the off-taker as part of the GPPA, given that the tariff that we pay under the generator power purchase agreement is an all-in tariff, we understand that the bankable financial model that the generator would submit to the commercial lenders financing the application would make sure that the generator is able to sufficiently meet these legislated and published use of system charges. And in order to ensure that this remains competitive, there are, of course, confidential contractual mechanisms, which we would be happy to discuss and submit in further detail to the regulator members in order to provide that clarity, but effectively would allow us to, in the event of changes, pass through various of these charges through to NOA Trading and from NOA Trading to the customer in that order. Then I believe the second question from regulator member Maseti was in relation to our intentions for trading. So, of course, as we've identified, the initial application is premised on the 6 Eskom-connected facilities, which are located in several of the provinces in South Africa. And that will indeed be the initial focus of the trading activity. However, the license is an application for a national trading license. And so it is absolutely the intent to supply all consumers in South Africa with the option to purchase renewable energy. And this is why the application is one for a national trading license. In respect of the third and final question from regulator member Maseti, the off-takers are indeed the anchor off-takers as Netcare has been identified, and we have executed agreements, but worth pointing out again that this is suspensive or conditional upon the license being obtained by NOA Group Trading and issued by NERSA. We do intend to supply many customers across the Republic of South Africa, and it is our stated intention to make renewable energy accessible to all consumers in South Africa, should they so wish to purchase it. I guess in final remark is just that to the extent that we have not addressed these in sufficient detail, we would similarly reserve our right to supplement these responses in writing during the prescribed 7-day period that follows this hearing. Thank you, Chair.
Thank you so very much for the responses and for your presentations and the offer to supplement to provide any additional information as you so wish, especially in line with the questions from the members. Thank you very much. I'd like to thank all three presenters today. This now concludes the presentation from NOA Trading. but you will be given an additional 10-15 minutes at the end of the after the ESCOM presentation for you to actually respond if you need to respond to any of the issues raised in the ESCOM presentation, as it is customary. With that, I'll then like to then step away from NOA trading and other presenters that were supporting the trading to now go to ESCOM. If I can see, I think the presenters, Mr. Hendrik Twala. There are two presenters, I assume from ESCOM. You are sitting in the same room?
Morning, Chair. Yes, we are sitting in the same room.
Okay.
It's Matlao Masekela and Sietsele. Hendrik Twala is not feeling well today.
Okay. All right.
Yes.
Great. Thank you.
Thank you.
Miss Masekela and Mr.
Sietswane.
Yes.
I always mix your name around. Okay.
I know you always have difficulties with the name.
I am Zulu after all, so I always have that as an excuse. Before we start the presentation, do you object, each one of you, to taking my list? Let's start with you, Taco. Do you object to taking an oath or an affirmation?
No objection, Chair.
Thank you. With that, kindly raise your right hand and affirm the following. Do you solemnly declare that the evidence and the information that you are going to give to this panel is the truth and the whole truth?
I do.
For the record, kindly state your name, the organization that you are representing, and your designation in its place.
My name is Matlao Masekela. I'm representing ESCOM. I'm in the distribution division of ESCOM in the legal department.
Thank you. All right, then let's swear you in, Mr. Sietswane. Do you object to taking an oath?
No objection, Chair.
Thank you. In that case, kindly raise your right hand and affirm the following. Do you solemnly declare that the evidence you are going to give to this panel is the truth and the whole truth?
Yes, I do.
For the record, kindly state your name, the organization that you are representing, and your designation in its place.
My name is Sietswane. I'm representing ESCOM in the distribution department, grid access unit.
Thank you. I assume between the two of you, you will decide who's making the presentation, and you're going to be assisting each other in responding to the questions from the members. You've got 20 minutes for your presentation. Can I, as is customary, hand it over back to you, and you can use your 20 minutes as effectively as you like. Over to you.
Thanks, Chair.
Presentation is visible. Thank you.
Thank you, Chair. Okay, Chair, as I've indicated that I'm Matlao Masekela, I'll be presenting on behalf of ESCOM. Chair, as ESCOM, our position has not changed from July. Chair, you'll recall that in July, ESCOM appeared before this committee, and the position of ESCOM was to object to the trading license application that was before the regulator. We are stating that that position has not changed. We are objecting even today. Chair, ESCOM is making this comment fully aware of the decision that has been taken by the Electricity Subcommittee on 1 October 2024 to recommend to the energy regulator for the approval of the trading license application that were objected by ESCOM. ESCOM does not agree with that decision of the ELS recommendation and the reason that were advanced in support of its recommendation. However, Chair, ESCOM will allow the NERSA process to be completed. ESCOM will wait for the decision of the energy regulator and the reason thereof, and ESCOM will provide the way forward. Having said that, Chair, ESCOM even today does object to the granting of the trading license of NOA trading. Of NOA trading license application on the same ground that were advanced by ESCOM in July 2024 against the trading license application that the ELS has now recommended to the energy regulator for approval. In short, Chair, we are saying that we have not changed our position. We are still stand by the previous objection. Even now we are objecting. Okay, can I move to the next slide? Okay, Chair, Proceeding on that one, as ESCOM, we have a concern with regard to most of the applicants who are making this application to NERSA in ESCOM areas of supply without first consulting with ESCOM. I heard the applicant, they did indicate that there is a connection agreement that is being discussed with ESCOM. But however, Chair, I need to confirm that to the extent that there was a discussion with ESCOM, that discussion has nothing to do with the trading application that is before the regulator. The applicant did have a discussion with ESCOM, and that discussion was with regard to them as being an agent of another generator, but not with reference to the trading application that is before the regulator for consideration. Chair, ESCOM has a direct and material interest in the trading license application sought by the applicant to trade in ESCOM license area of supply. And as a matter of principle, Chair, ESCOM ought to have been consulted first by the applicant. The recent trend by the various applicants for not appreciating ESCOM's right in ESCOM license area undermine the ESCOM's right as a licensee. It cannot be correct that ESCOM must learn through the media that someone has applied for a license to trade electricity in its area of supply where it is a direct and material interest without being engaged. So, Chair, in essence here, we are saying on numerous occasions we've been on record complaining that most of the applicants, whether it's a trading license application or it's a distribution connection facility application, ESCOM is not consulted, and each and every time we have to appear before the regulator to say we ought to have been consulted because we are the licensee in those areas. We have a direct and material interest. So someone cannot just apply without consulting us. Even on this case, we are saying that we are not consulted insofar as the trading license application is concerned, and that is our area of supply. Chair, we are basing that argument on the basis of the Electricity Regulation Act that defines supply as trading, generation, transmission, or distribution of energy. Trading licenses are applied for by the applicants who will, upon the issuance by NERSA, enable the holder of such licensee to sell electricity to ESCOM existing customers within the license area of supply as stipulated in its distribution license. Although such licensed traders will not own any electricity network infrastructure, but rely on ESCOM electricity network to transport the electricity to its customers, this arrangement will result into two or more licensees supplying in the same area or customers within another licensee's area of supply. So, Chair, on 29 July 2020, NERSA approved and issued rules for licensable distribution area, which prohibit the following activities. Chair, we are on record on numerous occasions mentioning these activities. I don't think I'll have to repeat them. They are on record. We did submit a detailed presentation to the regulator yesterday, where we outline this prohibition. What we are saying that the application that is in front of the regulator there contravene these rules that were approved on the 29 July 2020, in the sense that you are going to have two or more licensees supply in the same area. And our interpretation that supply means trading. So that activity that is before the regulator is prohibited, Chair. So I'm not going to repeat what is in the rules, but I did mention in the presentation. So, Chair, the rules define a licensee as a holder of a license granted or deemed to have been granted by the regulator under the Electricity Regulation Act. The trading license applicant will, upon the issuance of the license, fall within the ambit of the licensee as defined in the rules and its prohibition as set out above. And that prohibition, we are saying, two or more licensees are not allowed unless we have given a consent. And I've indicated that we have not been consulted and we have not been given a consent. Chair, as ESCOM, we are saying that the development of the rules was informed by several disputes or complaints that were lodged with NERSA in respect to what was termed as customer poaching by both ESCOM and the municipalities against each other. And Chair, the colleagues from NERSA will confirm that the previous year, ESCOM and the municipalities appeared on a number of occasions before the regulator, where there was a dispute with regard to who must supply who, where it was indicated that once the customer falls within my area of supply, another licensee is not allowed. However, it was not clearly indicated, hence the rules were developed to prohibit that, to say once there is a licensee that is distributing and supplying, so another licensee is not allowed. Hence, we are also objecting to this to say it will be contrary to the rules. We have not consented. So the importance of licensees talking to each other and presenting letter of concern or proof attempt to engage as part of the application was also discussed and incorporated into the rules. I've said this on many occasions, Chair, to say we ought to have been consulted, whether we agree or not. If we have agreed, we will have not objected to this application. In these instances, we have not agreed, hence we are objecting. The licensing processing for electricity and required document for processing insofar as what is termed supply, e.g. distribution as well as trading, need to be consistent. Equally, NERSA decision must be consistent with the rules. So what we are saying that the decision that was taken by the subcommittee is inconsistent with the rules. However, ESCOM, as I've indicated, that we will respect the NERSA process to complete the entire process, and we will get the reason for decision, and ESCOM will make a decision on that. As we proceed, Chair, the approval of the trading and license application under the current regime will lead to the following. Under the current regime, we are referring to the approved rules, the ESCOM license condition, compromise the efficient, effective, sustainable, and orderly development and promotion of electricity supply infrastructure within South Africa. The other issue we are saying, this will lead to cherry picking of customers. The applicant, by specifying target customers in the ESCOM license area of supply, may reasonably considered as cherry picking, and that will negatively alter the ESCOM customer mix. That is notably if the selected customers are inter-tariff subsidy contributor and who rationalize the price of electricity for all in the license supply area. So, Chair, this is one of the contentious issues that ESCOM has been raising to say the trading license application that are before the regulator, this one and the previous one, we have noted a trend where there's a cherry picking of customers, and this will create a negative impact on those customers that rely on the cross subsidy. Hence, we are saying that before NERSA consider this application, the rules must be amended so that all the concerns that ESCOM has been raising are considered. So in conclusion, Chair, as ESCOM, we are saying that we object to the granting of the trading license to NOA. ESCOM is on record confirming that it remains committed to transform and support an orderly transition based on established rules. The legislation, applicable rules, and ESCOM license, together with this condition, must be respected and taken into consideration by NERSA when making a decision. ESCOM proposed that NERSA conduct an industry-wide workshop that will assist in crafting the rules that will regulate the electricity trading market, given the current electricity distributors' licenses and rules. We are aware of the other traders that are in the existent, but due to a high interest on this matter, there is a need to introduce new rules that will be followed by everyone. In essence, Chair, as I've concluded, as ESCOM, we are saying that there's a need that the rules need to be amended, considering that if NERSA have to approve this trading license, according to ESCOM, that approval is contrary to the already approved rules and ESCOM license conditions. Hence, we are saying that we're having some difficulties with the recommendation of the subcommittee to the energy regulator, but we'll respect the process and wait for the decision of the regulator. And ESCOM will pronounce its position when the decision is made with the resent for decision. So I have concluded, Chair, unless if my colleague Sedzele wants to add something.
Yes. You can exit. I think, Chair, I'll just provide 2 clarifications with regards to the amended distribution connection use of system agreement, and specify that and clarify to the committee that as things stand, ESCOM or the distributor has no relationship whatsoever with NOA as the trader. The distribution connection use of system agreement is concluded between the generator, which is the IPP, and ESCOM as the network service provider. And this further emphasizes the objection that we are raising here, that we have a trader who has exaggerated their administrative function in terms of them being the nominated party. But as a supplier and as a distributor, we have a trader, the scope, the geographical footprint of their trading activities are unknown to us. They intend to supply customers who are connected to our network. And this is an entity that we have no relationship with whatsoever. We are not aware of their existence. And if they are licensed, we are not even aware of the scope and the extent of their licensed activities as a trader, including their geographical footprint. So, Chair, these are I just wanted to clarify that issue on the connection and use of system agreement, that there is no relationship whatsoever that us as the distributor have or with NOA trading. Our relationship is purely with the generators who are bringing electrons onto the network. Okay, thanks. I think that's the one clarification I wanted to provide. Thank you, Chair.
Thank you, Chair.
Thank you, Ms. Masekela and Mr. Tswane. Thank you for your presentation. You may choose to actually keep it on the screen if you so want, unless you've shared the presentation with the members. It does assist with the questioning, so members can point to a particular slide. But nonetheless, members, we have the presentation before us from Eskom. If we can then proceed with the questions, starting with Madam Simani.
Thank you very much, Chair, and a very good morning to our Eskom and stakeholders. I just need a few clarity-seeking questions. I have two clarity-seeking questions, Chair. The first one, I just want to confirm from the Eskom team, are they saying that the confirmation of engagement between them and NOA that we were finished with as a regulator is for a different matter? So I just want clarity to that. The second one is that I just want to understand, upon learning about NOAA's trading license, have they raised the objection with the applicant directly prior to them coming to the public hearing? Thanks, Chair.
Thank you, Madam. Mr. Mkhize?
Thank you, Chairperson. I'm partially covered by Madam Simane. Thanks to the two presenters. I would still maybe would like to know what is the expectation from them? Because it's one thing to say they needed to consult, but what is the expectation? And in view of the gap, if they can just not necessarily right here and now with regard to a comprehensive response, but as to what is the expectation, what gap is there, and how that gap needs to be closed in their view, whilst expeditiously dealing with the granting of or assessment of licenses of license applications for trading. I will leave it at that. Thank you.
Thank you, Mr. Mkhize. Madam Maseti.
Thank you, Chairperson, and thank you to Eskom representatives. I do have a couple of questions, and I think these need to be really clarified so that we can fully appreciate the source of Eskom's grounds for objecting or for opposing the application. Let me start off by asking a question as to whether there are any rules developed by NERSA which require that before a trader submits an application for a trading license with the regulator, that trader must have obtained some sort of agreement with the distributor that is licensed for operating a distribution facility in the specific area? Is there any prerequisite for traders that are supposed to approach the regulator for a regulatory approval before they can commence with their trading activity? I think that question for me is important. The second question that I would like to clarify is the issue of cherry picking of customers. Maybe Eskom, you need to assist us in terms of what exactly do you mean here, and what exactly is your concern here? And in relation to this, is it illegal for new entrants poaching customers of a competitor? Assume that Eskom was a competitor, although as far as I understand it, Eskom has been licensed to operate an infrastructure, the network in the area. So to operate a distribution facility in the area. And what is before the regulator for determination today is the trading license. So we're dealing with the issue of infrastructure versus the issue of trading power in the area. So I just want to understand here, and I understand the definition that you have put out there about the supply, what it entails. But I'm asking whether it is illegal for new entrants. Assume that supply and trading would, be doing the same thing. But is there anything that is illegal anyway for poaching customers of a competitor or a potential competitor when new entrants want to come into the market and offer competitive prices and operate in that market? Where, in what legislation is that prevented? May I just be clarified on that specific issue? And then also just to understand whether Eskom understands its role of operating a distribution facility as the same role as trading of electricity. Can we just understand that so that clarity is provided, and also so that the energy regulator going forward as its approach, it can be in a position to provide clarity and predictability to the market in terms of how it would look into these things, so that everybody understands the interpretation of the regulator, and also clarify the understanding of the role players or the licensees that in the industry with regards to trading versus the operation of a distribution facility. I just want to get an understanding to that. Chairperson, I think the last question that I would like to understand, now that the regulator is considering this application, is there anything that prevents the regulator from considering the application, at least from Eskom's perspective? Are you saying that the energy regulator is considering this application because Eskom has not been consulted? And even if Eskom has not been consulted by the applicant, even if it were to obtain a trading license, when the applicant is ready to operate, surely it will not operate until it has engaged with Eskom so that it gets access to the essential facility, which is that distribution facility that is operating in the area where the trader wants to operate. And one has to also give due recognition or consideration to how regulators approach an issue of an essential facility to the extent that one that operates it refuses access to such essential facility that would enable the trading activity to take place. If that can also be clarified, if ESCOM has that understanding as to the regulator ensuring fair access to areas where there's network, especially if network becomes a national monopoly and an essential facility, and refusal thereof, there could also be implications. I just want to understand that. That's all, Chairperson, from my side. Thank you.
Thank you, Madam Massetti. Advocate Sithole.
Thank you, Chairperson, and thanks to the ESCOM team. Chair, I just have 2 points of clarity for the ESCOM team. Chair, just on the first one is just to add on the question that the other members have raised on the fact that ESCOM has indicated that they have not been consulted. They learned of the application through the media. And Chair, my understanding is that the applicant, or in terms of the requirement, the applicant is to advertise its application, and the purpose of that is to solicit comments on any interested and affected party. And I would assume that this is the same understanding on ESCOM's side. However, they can indicate whether they differ or not. And if I am correct, Chairperson, I just want to find out whether why has ESCOM not raised its issues at the time of noticing that particular media advert on this particular application. Chair, the second point is that ESCOM has indicated again, or rather said they have not been consulted. I just want to find out that if the applicant has not consulted ESCOM, has the customers that are mentioned in the application approached ESCOM to negotiate their agreement with ESCOM such that they are able to move to the side of the applicant? Chair, those are my 2 questions for clarity to the ESCOM team. Thank you very much.
Thank you, Advocate Sithole. I see no other hands from members. Thank you for the questions, members. I have a couple of questions for you, Madam Masekela and Mr. Sethwane, based on your presentation. Can I just ask the first question? In your understanding, you talk about the definition of supply. Is it in your understanding that the definition of supply in the 1987 Act, the same as the definition of supply in terms of the 2006 Act? The reason I'm asking is that in the 1987 Act, the regulator was supposed to issue 2 types of licenses, generation and supply. So do you think that in ERA, does ERA regulate supply? Is there a license for supply? And contrast that with whether was there a license for supply that was granted by the regulator in terms of the 1987 Act. So those are in terms of supply. So if you can maybe just give us your understanding. Yes, supply is defined both in the ERA as well as it was defined in the 1987 Act, but the definitions, do you think that they are different or are the same? And that even if there is still a definition of supply in ERA, do you think it's the same in respect of saying that in the 1987 Act, wasn't there an explicit requirement for NER or Electricity Control Board at the time to issue licenses in respect of supply? Does that still apply in terms of the Electricity Regulation Act of 2006? Now, to also then talk to what the members were coming up with, all the questions asked by the members. Do you not believe that the the requirement of Section 13.3 of the Act that the regulator must issue a license to operate a distribution facility separate from that of issuing a license for trading. Do you see those as the same as what was in the past? Don't you believe that that requirement forces the regulator to consider these two licenses separately, as the license to trade versus the license to operate a distribution facility? Linked to that trading license, do you believe that the trading license is restricted to a region? That when someone applies for a license for a trading license, that in fact the trading license should be, if granted, should be granted for the areas for which that trading license was applied for? Or do you believe that trading licenses are national, as being applied for in this case, and has been applied for by many other traders before this one? What's your view? Is the trading license restricted to a particular region, or to a particular, as you call it, in brackets in my name, restricted to a particular area of supply? And do you believe that if someone has been granted a license in a particular area of supply, as you see it, that license then gives them an exclusive right to trade in that area? That in the event that somebody else wanted to trade in that area, they would need to have the permission of an existing trader to be able to trade in that area. My last question, especially when it talks to cherry picking, if maybe you can just explain this. Do you object to Schedule 2 registration process? As you would know that in respect of Schedule 2, registrants are allowed to have a supply agreement with the customer, and they go out and seek out customers. Would you not see that as also cherry picking? Or are you saying the Section 9 process of the Act is different, and you are okay with that, but you are not okay with this particular process? Or do you object, or do you see a challenge in respect of registrants that are going to particular customers and actually supplying and obtaining? I'm talking now if those registrants happen to be IPPs, as you call them, private IPPs, but who are the private IPPs having direct relationships with customers. In the case, for instance, of the application before us, if the registrant that, in respect of that wind registrant, I can't remember the name offhand now, if that registrant has a direct relationship with Netcare and also still wills power, is that in your case acceptable? And do you see that as different from when there is a role that's played by a trader who is now a go-between between the producers and the customers? And if your answer to that is you don't, it's okay, or you think that it's not okay, the question therefore that I may ask is, why have you not necessarily raised the same objections as we implement the Schedule 2? So those are the questions that we will pose to you. And as it is customary, you can respond to some of them that you choose to respond to in verbally now, or you can respond to them in writing within 7 days, so that at least we can give the regulator clarity as it makes a decision on this matter. I note your hand again, Advocate Sithole, if you can then pose your question, an additional question.
Thank you, Chair. Sorry, I missed this one. I was reminded by what you've just said at the end. I just wanted Eskom to confirm if it does have a use of system agreement in which there is a willing provision with the wind garden energy chairperson. Just a confirmation on that. Thank you.
Thank you, Advocate. Right, Ms. Masekela.
Yeah, through you, we didn't hear the last question from Advocate. You were saying we must confirm what?
Advocate, if you can come back, so I don't put words in your mouth. Advocate Sithole. But in essence, all that she was asking is that does Eskom, can Eskom confirm whether they've got a use of system agreement with Wind Garden as a registrant? Do you have a use of system agreement with them? If you can confirm that, thanks. Over to you.
Thanks, Chair. I will be responding together with my colleague Sedzele, and also some of the question we will supplement in writing where we have omitted to respond to some. Then we will still respond in writing. We will listen to the recording and do a supplementary response. Chair, from listening to the question from the members, I think the issue of consultation seems as if is one of concern. Chair, where we are sitting at Eskom, if you have listened to our presentation, we are saying that as a licensee that have a direct and material interest, the rules of natural justice dictate that one must consult you. I have a direct and material interest. And the area that you are talking about, I have a license to distribute, I have a license to supply, and those are my customers. Surely I cannot be expected to say you will raise your concern through the newspaper advert. Someone was supposed to come to me and say, I have an interest in your license area of supply, where you distribute, where you supply, and then with respect to your customers. Our argument is based on the natural rules of justice, which are the common law principle to say one must be consulted. Our right, we have vested interest in those areas of supply. Here we are consistent to say we must be consulted, where we must understand the nature of the application and the impact to Eskom. In certain instances, it does happen that we might agree, we might consent, and where we do not consent, we will come before the regulator to say we are not agreeing on 1, 2, 3, 4. The application or the objection, if there's any by Eskom, will be on a narrow point where we did not agree during our discussion with the applicants. So where we are sitting and we want to confirm to say we feel like we've been undermined at Eskom, where we are expected to respond where we have an interest through the newspaper advert. We need to be consulted. And on that one, we have raised it in many applications, whether it's the trading or the other applications. So there was also a question asked as to whether what is Eskom's position with regard to that recommendation to the energy regulator? What do they expect from the energy regulator with those recommendations from the subcommittee? As I've indicated, Chair, as Eskom, we don't agree with those recommendations, and our expectation from the energy regulator is that they must not approve those trading license application on the basis of the argument that we have advanced to say is against the rules, is against Eskom license conditions. If they approve, it will be contrary to those rules and the license condition of Eskom, as we have indicated. So our expectation from Eskom is that the energy regulator must not approve that application, but we will respect the process. We will wait for the decision of the regulator and the reason for the decision thereof. So there was another question that was asked relating to what is my understanding as Maklao relating to the 1987 and the 2006 insofar as the supply is concerned. Chair, I will I'll confine my response to the 2006. The 2006, my understanding that supply means trading, distribution, generation, and transmission. Hence, we are saying that in terms of the NERSA rules, 2 or more licensees are not allowed to supply in one area. Supplying meaning trading. And the question was asked as to whether is it my understanding whether I understand that one needs to have a license to operate a distribution facility and also the trading license? Yes, I understand and I can confirm that at Eskom we do have a we are licensed to trade, and that authority come from the letter that NERSA wrote to Eskom on the 3rd of September 2007, when NERSA confirmed that Eskom does not need to apply for a new trading license. All the activities that Eskom has been conducting in relation to trading, import and export are deemed to be licensed activities in terms of 2006 Act. So where we are sitting at Eskom, we are saying that yes, we are a license to trade, and that is a confirmation that was given to us on the 3rd of September by the regulator to say there's no need to apply for a trading license in terms of the 2006 Act, because we are already deemed to trade, to import and export. So then it goes back to the issue of supply chain. Supply is trading as defined in the Act, in the 2006 Act. That's where we are standing to say those rules mean supply. It means it's trading. What the recommendation that are contrary to the rules. Hence, we are saying we are having serious challenges with that recommendation. So my colleague Zele will will respond to some of the question.
Okay. I think there was a question raised, Chair, on the issue of consultation. I think for the record, we've had interactions with NOA Trading. But we need to contextualize those interactions. Eskom has not been consulted specifically by the applicant with respect to the applicant's intentions to submit a trading license, and for that matter, a national trading license as contemplated in the current application. The interactions that we've had with NOA were with regard to their agency role, being a nominated party, where once again, as I indicated, that's an administrative function on behalf of the IPP generator, and it gives no rise to any legal obligations being incurred or any contractual relationships between NOA and Eskom. And then the second question was, what is the expectation from Eskom, and how do we close the gap? Our expectation, Chair, is that we expect the regulator to apply its own rules regarding licensable areas of supply. For us as the distributor and as the supplier, we do not think, or rather, let me use positive terms. I think the appropriate route to be taken is for the rules to be amended if need be, or to be developed if there are any gaps in the current rules, so that we can establish a rule-based order for the licensing of traders. And that rule-based order will talk to some of the concerns that we have raised as Eskom. And primarily, we are a licensed trader. We own, and we also own the infrastructure. We are also governed by the rules of non-discriminatory access to the grid, and we need to allow and make efficient use of that grid. And having said that, it's important for us that in the application of those rules, we all understand what the rules are. We do not think it's appropriate that we have this licensed traders that have no relationship whatsoever with, and that we are not aware of as the supplier, because such a contractual relationship also doesn't exist between us. They are trading in our areas, they are supplying to our customers, and we are not even aware of them. Our submission is that when the rules are developed, they must also define geographical areas. They must be limited to specific areas of supply. It's possible that a trader could have multiple areas of supply, but that should be within within the rules, Chair. We do not object to that as long as it's specified and is properly documented on our rules. And then there was also a question that was raised by Maseti, regulator member Maseti, around the cherry picking of customers and what the real concern is. In our submission, we refer to the issue of intra-tariff subsidy contributors. And we are making an assertion that this cherry picking of contributors to the intra-tariff subsidies allows certain customers who should be contributing to some of the most important socio-economic subsidies as a country. It allows those customers to evade and avoid those subsidies. And the burden of those subsidies, more and more, the burden of those subsidies is left with those customers who are remaining on the network. So we are really increasing that burden on the existing customer, and it's also contributing to the utility death spiral, as it is termed in other areas. And we think when the rules are developed, or when the rules are improved or amended, as it is our position here, the issue of the evasion of this intra-tariff subsidies needs to be properly dealt with, so that as Eskom, we welcome competition, but that competition must be on an equal footing. It cannot be that certain entities must carry the socio-economic burden of the country and others are finding other means to evade the sharing in of those socio-economic burdens in the form of subsidies to our most vulnerable, the indigent, including those who are on our home light tariffs. So that is the point with the cherry picking of customers. We do not object to customers, or including the Schedule 2 registrants picking their customers, but we just have to ensure that where us as the industry, we are expected to make certain subsidies to the vulnerable in our communities, that burden is carried in a manner that is fair, and we can still remain competitive. So I hope that addresses the issue around the concern on the cherry picking of customers. I'm trying to look at if there is anything else. Chair, I think you have partly touched on the issue that was also raised by Nhlanhla around Schedule 2 and bilateral PPAs. We welcome. As Eskom, we welcome competition. We have an energy deficit to resolve in this country. And then we also have an affordability crisis that we all need to resolve in this country. And we believe that if we have a rule-based order where the rules of the game regarding the licensing of trading activities are properly defined and we all comply with those rules, then we will have a fair playing ground, and then we remain committed to providing non-discriminatory access to our grid. But having said that, we object, and we strongly object, Chair, to anything or the licensing of activities that is in contravention of the existing licensable, the rules around the licensable areas of supply. And once again, we emphasize, and it's our key submission, that we do not think the current application ought to be granted because of non-compliance with the rules on the licensable areas of supply. Thank you, Chair.
Thanks, Chair. We will also supplement our response in writing and share our presentation. Chair, thank you.
Thank you so very much to both yourself, Ms. Masekela, and also Mr. Setswane. for your presentation. As you've committed, you will supplement your questions, and as you've indicated, you're going to listen to a recording and see, because there are a number of questions that you did not respond to, at least not respond to directly. If you can maybe just provide direct responses to those questions within 7 days, we'll really appreciate that. And any other guiding material that you would want the regulator to actually have as it considers this particular license. With that, I'd like to thank ESCOM for the presentation. Thank you.
Thank you, Chair. Thank you, Chair.
Thank you. You can now. There's always an AI, Chief, you're an AI note taker. Okay. As long as colleagues, as we take those notes, remember that the only record that is an official record is that is kept by NERSA. I will appreciate that. Thank you. Now we'll go back to NOA trading, give them an opportunity, right to respond. We'll give you 10 minutes. To actually respond to any of the issues that's been raised. Again, you can also supplement any of your further responses today with, you can include your further inputs in your formal written submission that you may choose to then provide within 7 days. Over to you.
Mr. Chair and honourable regulator members, we wish to thank you for the opportunity to respond to the presentation submitted by ESCOM. We also wish to thank and acknowledge our ESCOM colleagues for their submissions made in respect of our trading license application, both the oral representations made today and the written submissions provided to us late yesterday afternoon. While we record our explicit disagreement with the submissions made, we would like to take this opportunity to expressly reserve our rights to supplement our responses during the prescribed 7-day period post this public hearing. However, we do wish to make a few interim remarks regarding the ESCOM submissions. It is apparent from the face of the written comments and the presentation delivered today that the basis of the objections advanced is substantively similar to the grounds advanced during the public hearing of the Electricity Licensing Subcommittee on the 18th of July 2024, during which 4 other trading license applicants received materially similar objections to the one raised by ESCOM today. We wish to place on record our support and agreement with the findings and the robust arguments advanced by the regulator members during the public hearing today, but also in the meeting of the Electricity Licensing Subcommittee on the 1st of October 2024, and confirm that it is exclusively the remit of NERSA to act as the regulator of the electricity supply sector, as is legislatively enshrined. In further support thereof, we have prepared and settled a detailed legal opinion which will be issued by an independent advocate, which deals with the merits of the ESCOM comments and contextualizes these within the applicable legislative framework. We intend to submit those to NERSA and the honourable regulator members, but also wish to tender this document to ESCOM in order to facilitate a speedy resolution to this matter. In this regard, we note that the delay occasioned by the previous objection on the same grounds resulted in a delay in excess of 2 months from the hearing date of the ELS subcommittee being until the ELS subcommittee was in a position to make its recommendation. We would request that the submissions raised by ESCOM be adjudicated upon as expeditiously as possible, as the impact of these submissions has significant ramifications for the broader electricity supply sector and South Africa writ large. The uncertainty and delay occasioned by the submissions has a pronounced chilling effect on new entrants to the market at a pivotal time when the ERA seeks to enhance competition and facilitate end customer choice in a liberalizing market. This is a sentiment endorsed by President Ramaphosa in his State of the Nation address and by the Honourable Minister Ramokgopa in seeking to accelerate investment and the renewable energy transition in the country. It also acts to cast doubt on the bankability of new generation facilities given an uncertain regulatory environment, the consequence of which is to stifle the much-needed domestic and foreign investment into our country. Investment which is required at a time where our country continues to face significant challenges in meeting the electricity demands required to sustain and stimulate economic growth. Finally, end customers such as Netcare and many others continue to lose out on the opportunity to remain competitive and continue their growth as they are unable to realize their cost-saving and decarbonization objectives which would otherwise be made possible through bona fide applicants such as NOA Trading. Any further responses in this regard will be contained in our supplementary written submissions, but NOA wishes to reiterate its commitment and willingness to engage with the regulator and Eskom and other stakeholders at any stage. Thank you, Chair.
Thank you, Mr. Taylor. I'd like to thank you, the team from NOA Trading, also from your partners, including Netcare, and also AIM, as well as thank the presenters from Eskom for clarifying Eskom's view. And it's quite clear that going forward, there's a need for clarification of trading. And I guess in our we may have come from a history which had a particular regulatory framework, those supply areas that are referred to. But the question that needs to be clarified going forward is the applicability of those supply areas in the 2006 Act. It's going to be even more important as we implement once the Electricity Regulation Amendment Act is being implemented or operationalized, because you're not going to have a proper market without a key major player who a player that will act as a counterparty, which is basically traders. So the role of traders will not be diminished going forward, but will be enhanced. But it's not going to happen until there's greater clarity in terms of the rules that are governing trading. So it's something that's going to be incumbent for all of us, from Eskom, from traders, from everybody that is interested in the electricity supply industry, to provide their views for us to actually have a better explained framework going forward. And the rules so adopted, firstly, that they must therefore be in line with the Electricity Regulation Act of 2006 as amended, but also they must be legal. So in essence, they must be legal and they must be constitutionally correct. So whatever that we do, we must remember that we can't act outside of the Constitution. So there's a lot of work ahead of us. Having said that, we as the regulator are obliged to make a decision on this particular application. We will do so, but we will probably hold an internal workshop first, just for us to then just to synthesize the inputs that we've received from stakeholders, and then we will then have an official ELS meeting, which is a public meeting, in which we will then deliberate openly in respect of the presentation that will be made by staff to the regulator members, and then we will then be able to recommend whatever that we recommend to the energy regulator. I implore all of you who have participated today that if you have any additional information, facts, and evidence that will assist the regulator to reach a good decision, please do forward it through. We know that unfortunately, the actual comment, the commenting process period has expired, and hence the public hearing today. But those that have participated so far, we really request that you actually provide any further input to allow the regulator to reach a good decision. With that, I'd like to thank everybody who's been on the call, the members of the regulator. I'd like to thank the members of the regulator staff, as well as the stakeholders, the applicant in particular, for a good engagement. The meeting is adjourned. I thank you all.
Thank you, Chairperson.
Thank you, Chair.
All present. Cheers.
Thank
Bye,
you.
everyone.
Thank you, Chief, colleagues,
Thanks
and
to
everyone.
everyone. Have a great weekend.